Okay, so we're back on the record, and now we're with Chapter 14, which is entitled Settlements, Dismissals, and Alternative Dispute Resolution. So what we're going to do is talk about a number of options to going to trial. When we're talking about wanting to resolve a case or a settlement of a case, there's a lot of things that go into it. First of all, how much time are you going to have to spend prosecuting this case in order to get a recovery? How much money are you going to be able to make? What's the best case scenario for you? Because especially if it's not a case that's going to yield a lot of money, maybe something less than 6 figures, then you might want to see about maybe trying to go in and settle the case and getting the maximum amount you can, which will be less than you might get from a jury. But then again, you take the risk factor out of play. You no longer have the risk of a jury coming back against you and not worrying about that. So that's part of the reasons why you might give consideration to a settlement. So in preparing a settlement, what I normally do is I put together a settlement brochure, which is also known as a settlement package. And what I'm doing is I'm presenting the facts of the case in the light most favorable to my side of the case. And I'm going to tell them some information about my client. And the thing about it is that you put in there, for settlement purposes only at the top of the page, so that no matter what you put in there, it can never be used against you. It can't be presented to a jury. It can't be argued to anybody. If it's for settlement purposes, discussions in furtherance of the settlement of a case are not admissible for any purpose. Otherwise, parties wouldn't talk settlement, because if somebody came back and said, "Look, I'll take $50,000," and then you say, "No, I'm not gonna take it," and then they go to the jury and they're asking for $300,000. It's interesting, ladies and gentlemen of the jury. I was on the phone with this gentleman not more than just a month ago, and they were willing to take $50,000, and here they are asking for you to award them $300,000. What do you think they think their case is worth? Well, you can't do that. People just wouldn't have. There'd be nothing to talk about, and you would always be at risk in doing that. So settlement negotiations, especially if you put them in writing, always put for settlement purposes only, and then that will explain a lot. Okay, so I summarize everything. The high points of my case, the best points of my case, the things that prior cases, maybe from this particular court, that were favorable under fact situations same or similar to my fact situations. And then and all of that's put together. I take photographs that I think are informative, that are helpful. I do a calculation of my client's damages. I break down the damages so that it's easily understood, because there's going to be an adjuster on the other side. The defense attorney has been hired. The defense attorney has been hired by an insurance company, and that defense attorney reports back to an adjuster, and he's going to report this information to an adjuster. Then the adjuster is going to make the ultimate decision as to whether or not this case gets tried or this case gets settled. And so that's another reason why you want to offer up information which is most beneficial to your case. So there it is right there, the settlement brochure. Facts, client's personal. I don't really get too much into the personal history, but the medical history and evaluation and the settlement demand, that's all a part of it. Settlement conferences. Sometimes courts order parties to negotiate. More often than not, the norm today is that they order parties to mediation. And I am a certified mediator. I've been doing mediations for 15 years, and I'm also a certified arbitrator as well. So I arbitrate cases, and we're going to talk about the difference between mediations and arbitrations and the roles of the parties in that. With regards to these settlement conferences, they basically just want to get the parties in a room. They want them to hash it out, talk about it, and see if they can't come out with some kind of an agreed upon settlement. And if they do, then they usually reduce it to writing. The parties sign off on it, turn it into the court, and the judge reviews it, and he says fine, and the case is dismissed. The parties pay whatever they agreed to pay, and the case is done. They release each other, and that's the end of the case. Like I said, settlement agreements are enforceable, and if you refuse, if you settle a case and you sign off on a settlement agreement, it is a contract. It's voluntary. There is consideration that is exchanged. You know, you have the legal capacity to do everything that you're saying that you have to do, and so as a result of that, parties need to understand that they can be sued for breach of the settlement agreement, but it rarely ever happens. In all the mediated cases, I've mediated hundreds of cases, and all those cases, I only had one instance where the parties made an agreement, they signed off on the agreement, and then they refused to comply with the agreement, and the other side turned around, and they didn't have to bring the original action to prove up their case. They just needed to sue them. And the good part about it is, under a breach of contract, unlike a tort action, a breach of contract action allows you to recover attorney's fees. So you go in and you make your demand, and let's say the parties settled the case for $40,000 and they breach that agreement. Well, you sue them, and not only can you recover the $40,000, but you can recover attorney's fees as well as other costs associated with prosecution of that claim. So remember, settlement agreements are enforceable. Okay, so I rarely ever see high-low agreements. What I see, and what we mean when we're talking about a high-low agreement is this. You cap the amount of damages, and then there's a high, and let's say the parties agree that under the best of circumstances, if a jury was to come back and it was, you know, the best jury you could ever ask for is going to give you $50,000. And in a worst case scenario, the jury's going to give you $10,000. And so the parties basically agree that some number between 10 and 50 is going to be paid. And so I've had this done when I've been in the form of an arbitration, because the parties agree to what's called a high-low arbitration, where the most that I could ever award, and they don't tell me what the high and what the low is. They have that agreement themselves. And so I go in and I award what I think the case is worth. And let's say I believe the case is worth $75,000 based on the high-low agreement. They would only have to pay $50,000 because they cap their damages at 50. Or if I came back and said, look, I think this case is worth $5,000 and that's what I'm going to award, then they don't have to, they would go up to the 10, because the 10 was the low, was capped as the lowest amount that would be paid. And so that's where the high-low agreement comes into play. But it's generally in terms of an arbitration, and you generally don't tell the arbitrator, because you don't want the arbitrator to award $50,000 if in fact he believes the case is worth less. But if he believes the other side's willing to pay 50, he's going to do that 50, and everybody's happy because they said, look, we'll pay 50, and the other side will take 50, and that makes it go away. So, the other thing that the settlement agreement should include is the identity of the parties. It's got to include the cause of action. It's got to include the claim number, the cause number, the court number. It also includes everything else, and it also has a detail as to exactly how the money is to be paid, and it's got to be specific. And it says, you know, the defendant, you know, and/or his insurance company agrees to pay to the plaintiff the sum of, you know, $50,000 on or before the expiration of 30 days from date of execution of this agreement. That would be it. And so, and it says where the money is to be paid, at the offices of the plaintiff's counsel, and the check should be made payable as follows. I mean, all of those things are details that can be in the settlement agreement. And then in the release, you're simply releasing the parties upon payment of that money. The party then is released from any further liability. So that ends it. And generally, most releases are going to be mutual releases. Both parties, even though the defendant wasn't suing the plaintiff and wasn't seeking anything, the parties sign a mutual release where both parties release each other from any and all claims, and then they sign the release. It's exchanged, the money's exchanged, and the case is over with. Okay, so the mutual release is the one that I was talking about. A partial release, generally, most parties don't agree to a partial release, because if they're going to pay money, they want the case over and done with. And so unless it's one party that's settling the case, but that's still a full release as to that party. So I don't really see the significance of a partial release, but usually it's going to be a general release of some sort that's going to release, and it's going to be, and there's also something else in the settlement agreements, and that is that there's no acknowledgement that anybody did anything wrong. Each party, the defendant specifically states in there that, without admission of any, wrongdoing on the part, that the defendant agrees to pay the sum, to buy their peace. Well, that's fine, and that's exactly what you want in there, because why should they make an admission? They're paying a bunch of money. They don't need to admit to anything. And then the mutual release is where both parties have agreed to release each other. So. All right, this is the information that I just stated, the consideration, and in the release, it will also describe in detail the cause of action, and basically it will say something to the effect of any and all claims that were filed or could be filed. Even if you didn't file the claim, those claims are being released. Even if you didn't know that a claim exists, that claim is going to be released. And the idea behind it is that once the money is paid, they don't ever want to see this person again. They don't ever, they don't ever want to hear from this person again. They don't want anything to do with this person any longer. And so the case at that point in time should be over. Okay. And obviously it's got to be executed by the actual plaintiff and the actual defendant. Now, when I do my mediations, I also have the lawyers for the parties. I sign off on these releases as well, and it's just an acknowledgement that they can't come back and say, well, I didn't understand the release. Well, your lawyer signed it as well, so I'm sure your lawyers understood it, so it avoids that particular issue. Okay, so this is what's going to happen. As far as dismissal of a case, it's a little bit confusing because they're kind of mixing apples and oranges. When parties do a settlement and they agree to dismiss the case, generally what it's going to be is a dismissal with prejudice. And when something is dismissed with prejudice, it means that you can no longer bring any action against these parties under any circumstance, and that's it. When something is dismissed without prejudice, it would allow a party to come back in if for some reason that there was something that was of a litigatable nature, that you could come back in and do that. So there's no reason not to make your dismissals with prejudice. So the second thing they're talking about is a voluntary dismissal, where the plaintiff agrees to simply dismiss their lawsuit. Now, that's true. That's true, but it's not often, unless the facts come forward and it shows that the plaintiff's claim is not what they believe it to be. Then they want to go ahead and get out of the case before the other side makes a motion for costs. And the third is a court-ordered involuntary dismissal. Now, it's very, very rare that a court will ever dismiss a case involuntarily. In other words, if you're not asking for the case to be dismissed, the court's not going to dismiss it, because what happens if they were wrong, then it's going to go up on appeal, and the Court of Appeals is going to have that case right back in your court again. So more often than not, dismissals are going to be of a stipulated type, and they're either going to be with or without prejudice, and that's what you're going to see. Now, if the plaintiff brings an action and then they realize that the facts are wrong and that they have no business bringing that action, then under that scenario, the courts will allow you to dismiss a case. But usually an involuntary dismissal means that you're objecting to the dismissal of the case, but the judge is going to dismiss it anyway. That's very, very rare. So you can also do a consent decree, which is also known as called a confession of judgment, where you're allowing something to be entered in against you for a stipulated sum of money, and then you can also ask for, and then there's going to be settlement funds can be distributed a number of different ways. More often than not, the norm that you're going to find for settlement funds to be distributed is going to be by and through a lump sum payment. And 99% of the cases are going to be lump sum. They're going to write a check for X amount, and in exchange for paying that sum, they're going to get a full and final release, or it's going to be some form of a mutual release. But whatever it is, it's going to be a release, and the parties have released each other. The sum has been paid, and then that's it. The case is over with, and so that's done. Now, there are other situations with regards to dismissal of cases or settlement of cases, and then there are funds that are paid periodically, and those are called annuities. And so you would pay the sum of money, and you would agree for a settlement to be paid over a period of time. And and you can have the certain sums that you want to have paid. And you can have, whether it be, paid on a monthly basis or biannually or annual basis, however you want. That kind of a settlement is effective, and it's usually if it's a very, very large sum of money. Insurance companies, though, what they generally want to do is they want to be able to go out to the market, and they want to be able to buy an annuity that will basically fund the settlement, and it will cost them less money than if they paid all the money in cash today. So that's regarding distribution of settlement funds. Okay, so alternative dispute resolution. This is a means of resolution of a case without having to go to trial, and this is at least early neutral evaluation. So in Texas, we don't have early neutral evaluation. Don't know what that is. This jurisdiction where this case was written from, they may have that, but in Texas, we don't have early neutral evaluation. We do have mediation, and that is probably the first and foremost means by which cases get settled is by and through mediation. And a lot of ex-judges, once they've been on the bench, they become mediators, and they make a lot of money. I mean, they can make $30,000, $40,000 a month mediating cases. They're expensive, and some of them are very, very effective, and some of them are worthless. Non-binding arbitration. I don't know anyone who goes to arbitration where it's not binding. And the reason is, why go to arbitration? Why pay arbitrators these exorbitant fees if the arbitration award is not of a binding nature? If the other side can just say, well, no, I'm not going to pay that, and then you'd have to go through the trial process, you might as well just go through trial as opposed to non-binding arbitration. In Texas, the only thing we have is binding arbitration. That's the only thing that at least anybody that wants to settle a case through arbitration that uses. Now, I used to arbitrate cases for the New York Stock Exchange and NASDAQ, and we were a panel of 3 arbiters, and we would hear claims against brokerage firms by clients where they were claiming that a brokerage firm was churning their money. I don't know if you guys understand that term. Churning simply means that you're buying and selling and buying and selling. And the idea behind it is on every buy and on every sell, you get a commission. So if you buy and sell often enough, you can run down an account so that there's no money made in the account. And a lot of people have complained that a lot of brokers, unethical brokers, would buy and sell in these accounts large sums of money, and they would take a percentage of that. And whether the stock that they bought made money or lost money didn't make any difference. They always get their commission. And so anyway, so that was all binding arbitration. Now, there is one situation where an arbitration award that's generally deemed as binding can be made non-binding, and that is if the arbitrator fails to disclose information that would be material to you having selected that individual as an arbitrator. For instance, if that arbitrator used to work for the law firm that's defending the case and doesn't disclose to you that he used to work for that law firm, that would be material. That would be information that you would want to know, because had you known that, then you probably wouldn't have selected that arbitrator. There are other bases, but that's the only one that I know of that allows an arbitration award to be overturned. Even if the arbitrator awards something that's not available under arbitration. For instance, an arbitration agreement is where an arbitration comes from. Arbitration is voluntary, and it is the parties agree to it, and they agree to select an independent third party as the arbitrator. But it's got to be a written agreement between the two, or else the parties don't have to arbitrate. You can't order someone to arbitrate. You can. They have to agree to arbitration, and usually, like in the brokerage agreements, if you let's say Merrill Lynch or Bayer or Oppenheimer, whatever, whoever your broker is, in that agreement there is an arbitration clause that says that in the event that the parties reach some kind of a dispute, rather than sue each other in court, that they will agree to appear before a tribunal of arbitrators to determine if there are damages and who's liable for those damages. And so that's generally what happens. So and here in Texas, the summary bench trial. Now, bench trials are used on a regular basis. People that don't want to have a jury trial, you simply go down to the judge and you present the facts and evidence to the court, and they then make the decision. The alternative to that is going to be a jury trial, and that's what you're trying to avoid, is the fact that a jury trial is going to be held. So the idea behind these various things is going to hopefully eliminate that particular obstacle, because jury trials are expensive. They're very, very time consuming. And the idea behind it is you never know what a jury is going to do. I mean, you could have what you think is the best best jury panel, and the next thing you know that they're finding facts that are in favor of the opposing side. So the things that we do are the things that are listed here. We negotiate. That's the settlement process, where we prepare a settlement brochure. Or back in the day when I first started practicing and I was doing personal injury work, I would just call up the opposing side. I said, look, we've been looking at the facts of the case, and obviously we think this case is worth a whole lot more than what we're asking for, but my client would be willing to take $50,000 to resolve this case. Talk to your client, give me a call back, and let me know what you guys can do. And then I would get a call back in a day or two, and they would say, look, we've got $35,000. And I'd say, well, the best my client will do is 45, and then they come up to 40, and then maybe at 42.5, we might settle the case, and then the case is over with. And that's it. And that's simply negotiation. The mediation is the thing that I do, and in preparing a mediation, it's a simple process. Everybody meets at my conference room in my office, and I have multiple conference rooms, and we all meet together in what's called a general caucus, and everybody's there, and I explain the mediation process. I'm not explaining it for the lawyer's benefit. I'm explaining it usually for the plaintiff's benefit, because the defendant is usually not there. And so I explained to them that, look, this is mediation. I am not a decision maker. I am a facilitator. All I'm going to do is try to get you guys so close that it just doesn't make good business sense to walk away without settling this case. And I want to hear, the strengths and weaknesses, and then I explain and make sure that they understand. And then I always tell them, I said, look, this is your last best chance to resolve this case without going to trial. So I suggest that you avail yourself of this opportunity, because juries are kind of a fickle thing. You never know what a jury is going to do. And I allow the parties to do opening statements where they talk about what they think are the strengths of their case. The other side will do the same thing. And then once they've done that, I break them up into separate groups. And I keep one group in that conference room. I take the other group to another conference room. And then we talk about the facts of the case as they see it, and what they think their strengths and weaknesses are. And I kind of shuttle back and forth. And then I get an offer from the defendants. I said, all right, I need a number. What is, or actually, before I go to the defendant, I have the plaintiffs tell me what is your what is your demand today? What are you demanding, to settle this case? And they give me a number that's usually much higher than what they really think. And they say, well, we want $100,000. And I take that 100,000 to the defendants, and I go in their office and I talk with them, and they say, well, look, we're willing to pay 20. And then I take the 20 back, and then they're willing to go down to 80, and then these guys are willing to go up to 30, and then so on. And then at some point in time, there's a number that they're both willing to agree to, or sometimes they don't. One guy says, look, 75 is it, and the other guy's stuck at 50. We're $25,000 apart. We're not close enough. And at that point in time, I generally then declare an impasse, or I do what's called I'll do like a mediator's offer. And what I do is I put a number down and I submit it to one side and said, look, if this number was offered to you, would you be willing to pay this sum of money? And then the one side, they look at it and they say, okay, this is a number that we would be willing to take. And then I go to the other side and said, if this sum of money was offered to you, would you be willing to take it? And then they say yay or nay. But I don't tell either side yay or nay unless both sides agree on that number, so that nobody ever knows what that number is. So anyway, there's just different ways of resolving these kinds of cases in mediation. The binding arbitration, I'm not a big fan of binding arbitration because I think arbitrators are a little too full of themselves. They think they know a lot more than they really do. And in a lot of situations, in one situation, I was successful. They were suing us for $50,000, $60,000, and I got the damages down to about $1,100. My client was happy until the arbitrator awarded attorney's fees. And then I looked at it, I said, you can't award attorney's fees. None of the causes of action that they're pleading gives rise or allows for the award of attorney's fees. And in fact, the arbitration agreement doesn't provide for attorney's fees. He didn't care. He just awarded them anyway. And so I went to the court, tried to get the arbitration award set aside or amended. The court refused to hear it. And so the award stood, and my client never paid it, and they never collected, and so it was just kind of a colossal waste of time. But so you can do this mini trial too, and basically what it is an abbreviated version of a trial where the parties are looking to be able to present evidence and kind of give their client a day in court, but it's not a full-blown jury trial, and you don't have all of the things that go along with that. But you do have a panel that looks at that and then makes a decision. And then you can also have judges that will sit. You can just do bench trials, which is not private judging. And then you can also hire judges who are no longer on the bench to sit and listen to the evidence of the case and to render a decision, which is more along the lines of what an arbitrator would do. But that's something that's not binding. So those are the options that are available to the parties in the event that they decide that they want to resolve a case, but they don't want to take the case to trial. Okay, so high-low agreement, we already talked about that. And this arbitration agreement, a baseball arbitration, I'm really sorry, but I don't know what that is. And I have been doing this for 35 years, and I've never heard of it. Let me see if I can find it here. 434. Maybe it's just something that they're calling it, and I've never heard of it because baseball arbitration, also known as final offer. Oh, okay. So they're calling it something different. Each side presents its evidence. Each party informs the arbitrator that what number it believes the award should be. The arbitrator must choose one of those proposed awards based on the evidence heard. Doesn't have the authority to select another figure. Okay. Night baseball arbitration. So that I've never heard of either. Parties submit their proposals in confidence to the arbitrator in a sealed envelope or otherwise after evidence is presented. Arbitrator then assigns a value to the case. The parties agree to accept the high or low figure closest to the arbitrator's value. Okay, so a high-low offer, this is, basically the same thing as what we're talking about here. So I'm not sure why they have to have something night baseball arbitration, because again, that's not. Med-arb is the dispute is mediated first, and if the dispute is not settled, the parties move into the arbitration phase, which would generally be binding. Now, what they're talking about here is that you go to a mediation and you try to, remember I told you that you can reach a point where there's an impasse, where the parties have agreed. If that fails, then the process now turns into an arbitration. We don't have that available in Texas, so I got to tell you, I've never seen that before, so I don't know anything about that. I don't even know if that's available here in the state of Texas. I guess the particular jurisdiction where this book was written does have that as an availability. And the same thing with the arbitration mediation, ArbMed, is where they go in and arbitration is allowed to act as a mediator after hearing the arbitrator. At the end of the arbitrator makes a binding decision that is memorialized but not disclosed. Parties then mediate. It just seems like a whole lot more effort. Look, you can go to a mediate. If you get a good mediator, you can go to mediation. You should be able to get your case resolved. A good mediator will bring out the high points, the low points, and he'll beat up on both sides. He'll make the plaintiff take less money than they ever thought they would take and make the defendant pay more money than they ever thought they would pay, and that's a successful mediation. I look at a successful mediation as being both parties leave my office and they're both unhappy. If they're both unhappy and the case settled, that to me is a successful mediation. That means that the plaintiff took less than they wanted to take and the defendant paid more than they expected to pay. So neither one of them is happy, but you know what? The case has been resolved, it's been settled, and everybody's down the road. To me, that's a successful mediation. So, okay. Okay, now during arbitration, like the case that I had that went to arbitration, we conducted some limited discovery. We were not under the AAA, which is the American Arbitration Association, and I never used American Arbitration Association. First of all, their prices are just through the roof. I mean, you know, they'll charge probably $5,000, maybe $6,000 for a 1 day for arbitrators' fees, and that's absolutely ridiculous. But the arbitrator doesn't get all the money. Some of the money goes to the American Arbitration Association, then he gets a percentage of the money, and that's just a lot of money for somebody to make for 1 day. I think it is. And so under the Federal Arbitration Act, now that's a different act that is for federally mandated cases, but it says in there what discovery will be allowed. For instance, you can do limited interrogatories. They generally allow you to exchange discovery, limited requests for production. They allow you to exchange some discovery and to do some stuff like that so that the parties can get a better feel for what's going on in their case, because when you're in arbitration, you haven't deposed anybody. You haven't done any of the discovery that you're going to do in a regular lawsuit. None of that stuff has happened. So when we're talking about this kind of discovery, this is the only thing that you've got to go on as far as evaluating your case. So it's very, very limited, but it does allow for certain things to be done, and it allows one party to get information that the other party may have, and as a result of that may help you with regards to either trying to settle the case before the arbitration occurs, or during the arbitration knowing what the points are that you need to make to the arbitrator in order to either get the money that you're looking for or to keep from paying money that the other side is seeking. So under both those scenarios, that it would allow for a resolution of the claim, and it would be less cost involved, and it would be something that could be done quickly. So, okay, so we've talked about the number of different settings here to try to resolve the case. We talk about settlement, and that's just simply lawyers picking up the phone and talking to each other, or putting some kind of a settlement brochure together where you put all the highlights of your case, your photographs that are supportive, medical records, medical bills, lost wage affidavits, all of those things, especially when liability is a given. If liability is not a given, then you might as well forget about it, because the other side doesn't believe that they even owe anything, much less the amount that you're asking for. And so, but when there is no question on liability and it's just a damaged case, then what you really need to do is put something like that together and show the other side what it is that you'd be presenting to a jury and that you think a jury would award a whole lot more than the sum of money that you're asking for, and see if that will work. And in a lot of instances that works. If that doesn't work, then you can look to the mediation process. Mediation is informal. It is something that's done where you can it gives your client the opportunity to have kind of like a day in court, because they get to talk about their case and you meet with them, and it's not like something's just being settled. It gives them the feeling that they're having a day in court. But without the necessity of court and without the risk of what's going to happen with a jury. The parties meet in the general caucus, they talk about the case, they give opening statements, you separate them, and then you just kind of use a little bit of shuttle diplomacy. You're back and forth, taking offers and demands to each other until you come up with a number, and then hopefully that resolves. And remember, if it doesn't resolve, it's declared an impasse, and then in some instances, they'll ask for a mediator's award, or where I will come in and give a number only to one side, see if they're interested. If they're not interested, then everybody leaves. If they are interested, I go to the other side, see if they would be interested in that number. If both parties have agreed to that number, then we settle the case for that number and the case is done. So arbitration, on the other hand, and when I'm an arbitrator, I am the trier of facts. I'm the one that determines the weight and credibility of evidence being submitted. I determine the credibility of witnesses. I determine, how much weight to give to their testimony. Somebody wants to introduce something into evidence, I determine if that's going to be introduced into evidence. All of those things are my decision as the arbitrator. I have absolute control over the entire process. And then in the end, I'm the decision maker. I make the decision as to, first of all, is there a finding favorable on liability? And if the answer is yes, then the next question is going to be damage, an award of damages. And then I make that damage award. I write it up into an arbitration award, give it to both sides, and then they go on from there. And that's an arbitration. So obviously I play a different role in arbitration than I do in mediation, but the whole end result is, the purpose with regards to each is to come up with a final agreement that everybody ultimately can live with. So, okay, so you guys aren't here to ask questions, and hopefully I've covered the material and you don't have any questions. And obviously when I come back next week, you guys can ask me any questions you want. I'll be happy to go through this, and that will be our final week. So with that, I will say good night, and you guys have a good weekend, and I'll see you next week.